with Association Help Now. We're in a lot of different states. Appreciate everyone being here. I am not in my regular, I'll call it a studio. It's not really that fancy. I am at my son's apartment in Miami, and I am dog sitting for 4 days, but I am his wife is away. So I'm absolutely thrilled to be here. And anybody that has adult children will probably understand why I am. So I'm a bit disjointed today. So just kind of bear with me here. Let's start off with the CEUs. Let's try to get that part out of the way. And I'm getting some background, but it may even be me. So you guys let me know if the sound doesn't sound good. I'm going to launch a poll. If you are here for CEUs, indicate which one you need. But everyone has a question feature. And I love for people to stay in touch with me today. Please send me comments, send me questions. I love it, especially with today's topic. I think we're going to need some help in what direction we want to go in today. We're here. We have a lot of lawyers. Let's take advantage of them while we can. I'm going to go ahead and close this poll. Everyone has a question feature like I just mentioned. Use it if you need CEU. Say, hey, Ray, you closed the poll too quickly for me. I need CEUs. And I'm looking at my iPad here that I have as a different screen. So that's why I'm kind of looking back and forth. Tomorrow, we are, Jennifer, everyone thinks the feedback's coming from you. So maybe mute because I'm hearing it too. I'm sorry, Jennifer. Tomorrow, the audience is telling me. So I can't reopen the poll. Use your question feature. Just say, hey, Ray, I need CEUs. Tomorrow, manager community panel discussion, crazy and mean people. And I don't mean like our panel. I mean residents, okay? So no, panel didn't even respond. Of course you guys aren't crazy and mean. I was just joking. Okay. Anyway, with that being said, that will be tomorrow, so please join us for that. All right, so what I'd like to do is have our panel introduce themselves with who I see first, and that is Corey.
Good morning. Thank you, Ray, for having me again. My name is Corey Kravitz. I'm the managing principal for Kovich Schifrin Nesbitt's Florida office. We're a national community association law firm with offices in Florida, Illinois, Wisconsin, and Indiana.
Corey, do you want to come and take me out to dinner tonight and pay for me and my son?
I have the firm's credit card.
It'd be very expensive. Okay.
What about the dog? You're watching.
The dog would stay here. The dog can stay alone. I'm
Don't
dog.
sound like much of a dog watcher to me, but okay.
Yeah. Dinners are pretty quick because they have a lot of rules with the dogs. They don't like the dog to be alone too long. All right, John.
Hi, John Legumina from the Legumina Law Firm in Purchase, New York. We represent condominiums, HOAs, and co-ops from New York City throughout the Hudson Valley areas.
All right. Deb.
Good morning, everyone. Deborah Girelli. I'm the Vice President of Girelli Insurance Agency located here in New York, in Cold Spring, New York. We have a department specializing in community association insurance. I have my CERMS designation from CAI Nationals, and I'm currently on the Hudson Valley chapter board.
All right. Valerie.
Hey, I'm Valerie Garcia Giovanoli. I'm an attorney with McCabe, Trotter, and Beverly. We're a full-service community association law firm located in Columbia, South Carolina. We also have an office in Charleston, South Carolina. I'm also on the South Carolina chapter board of directors for CAI and on the Blue Ribbon Committee.
Casey is saying, I'm not going to use, I don't use people's last names, by the way, so I forgot to mention that. Feel free to ask whatever you like, and I'm happy to pass along. I could make a mistake, so don't say anything too top secret. I'll just use first name. Valerie, Casey says, yay, Valerie, she's awesome.
Hey, Casey.
You know, Casey, I would like to know, I think Valerie's awesome too, but I would like to know exactly why you think Valerie is awesome. So if you can send that over, I would like to know what you are referring to. Thank you. Dave.
Hey, good morning, everybody. My name is Dave Byrne. I am the chairperson of my law firm's community association practice, Ansel Grimm Aaron, and I represent condominiums, co-ops, HOAs in New York, New Jersey, and Pennsylvania.
Didn't take very long. Casey said that you are so smart. So There you go.
Thanks,
So
or
obviously
just have her
she meant
full.
it. Okay, she meant it. She typed it pretty quick. And thanks, Casey. I actually appreciate the comments very much. Jennifer.
Hi, good morning, everyone. My name is Jennifer Eggleston. I'm in Myrtle Beach today, and I work with Hotwire Communications. I'm the Community Relations Manager for the Carolinas. We're a fiber to the home internet service provider and the 11th largest privately held internet service provider in the United States. We work solely with homeowners associations. If your association wants a fiber optic solution for the homeowners, please feel free to reach out to me. Thank you.
So on Monday, Jennifer spent the day with me. I visit management companies and I videotape and do a bunch. So I need somebody to help me. So Jennifer was nice enough to ride around with me all day on Monday. And she works really hard helping me because somebody's got to hold the camera and just let me be a pain in the neck. But anyway, Jennifer, tell everyone how dedicated I am to my job, what position you were in, and I abandoned you. Why don't you tell everyone? Because I felt bad, but I had to because I had an appointment.
No, you're absolutely dedicated. And unfortunately, I couldn't carry on because my tire lost pressure. So Ray abandoned me while I had to go get my tire filled up.
I said, I'm really sorry, Jennifer. I'm here to work. I got these other appointments. I'm going to have to abandon you. She was not on the side of the road. She was in a parking lot, but I completely just abandoned her and went on to my next appointment. So I felt bad about it. So I guess if you feel bad, hey, I guess it's not so bad. All right, Jennifer, why don't you jump off because you're going to come back and you're always nice enough to give something away. And we always appreciate that very much. And you guys will just kind of have to imagine what we have going on here today. There was a question that has been sent to me like 4 times. I just want to get to it before we start the topic. The question is, one home the police have been at 2 to 3 times a week. Owners want the board to take action. Docs have an obnoxious behavior nuisance clause. The question is, should the board step into this mess? And I don't want this to turn into a whole topic, but Corey, can we give them a kind of roundabout answer?
This happens often. We get these calls often. Sometimes it's domestic issues. Sometimes they're selling drugs. If people are coming out into the street screaming and yelling, sometimes there's a distinction if they're tenants or homeowners. Generally speaking, if it's a criminal matter, then you probably just let the police handle it. But if it's something that happens often and there's tenants involved, then some associations will use the general nuisance provision to either not renew a lease or have the tenants removed.
John.
Yeah, so you're usually HOAs and condos, you're very restricted in what you can do. But as Corey mentioned, there is a nuisance rule. You certainly can send a warning letter and issue fines. Other than that, unless you have special remedies in your governing documents, there's not much you can do. And also, if it's a crime, the witness to the crime needs to report it to the police, not the board. The board is not responsible for reporting crimes. It's the police want to hear from the eyewitnesses.
Great point. Valerie.
Yeah, I would just say, I think Corey and John covered it all.
Yeah.
That's it.
Yeah, I mean, Dave, is it covered? Or do you have anything to add?
Yeah, those guys covered it well. I would dissuade a client from even getting involved in this. I would seriously doubt that all these people that are calling to complain are actually going to be willing to sign a certification, an affidavit, or testify in court against any of these people. I gather that it'll be anonymous. They'll refuse to participate, and you will go nowhere on a practical level, even if legally you had the right to do it.
I was gonna add something. Sometimes I see you're nodding and you're like, hurry up. But I was gonna add that I do think arguably for the other owners, at least what the situation I run into is a waiver that you're not enforcing the nuisance provision against these people and therefore you've waived it against other people. So that might arise as a defense in another case. I also think there's an argument that it's the board's fiduciary obligation to enforce the covenants. And so it might just be a, hey, notice a violation. You're violating the covenants, please stop. But at least you're asserting your rights. Then you can, business judgment rule, you can decide whether or not to escalate it or take additional steps to remedy the issues.
I don't want to get into a whole topic about this, but what I don't like is when something's called a nuisance because it's not very well defined, right? And it seems like it could turn into a discrimination lawsuit if you're not careful. Am I wrong, Valerie?
I mean, it potentially could if like you're selectively enforcing that covenant against people of a minority, or protected class rather.
But one person's nuisance is maybe another person's enjoyment, like if it's related to music, and some people just don't care. That's why I just think it's a tough one. All right, does anybody have anything else to comment in that regard? Okay, Deb, any insurance issues? No? Okay.
There's
I'm gonna
always
launch-
insurance issues, right?
Yeah, it's not an open
I
question.
know.
That is.
But yeah, so there's a fine line on when you get involved in something. And I'm with the attorneys that you need to, always enforce the covenants in a equal manner. But when it has to do with police involvement, I would always say stay clear of that and let the police handle the matter.
Okay, got a couple different answers there, audience. So, okay, so this topic is how your next post, message, or AI draft could put you at risk. And I think I'm going to want to start with the AI part because, audience, you let me know about which part you're here for, and we'll try to start off with that part. And also, I'm getting more Valerie comments. You're welcome to send them, but I know she's wonderful. Valerie was our HOA attorney several years ago and helped us tremendously on multiple issues. Valerie really is so smart. Valerie is just terrific. It's just going on and on and on. Okay, we understand. We all know that Valerie's great. So, but they're much appreciated comments. I'm sorry, John. I don't see any comments about you. And if it doesn't makes you feel better, no one ever sends me a comment. So, okay. That being said, I am going to launch a poll to get the ball rolling here today while people are sending their stuffs in. And it is going to be, oh, no, I'm not going to launch this poll now. Okay. I'm going to ask as a question. Do you ever post text or use AI related to association business? So audience, if you could use your question feature, I would appreciate it if you would let me know. Do you ever post text or use AI related to association business? And when we mean text or post, I think we're referring to personal phones. I think that's going to be a factor here today. Corey, before we go any further with today, while people are sending in their commentary, why do you think I mentioned the difference between business and personal phones?
Well, I mean, I know I do. Some people use their personal phone for business and their business phone, or they have two different ones. Just like with emails, you usually want to have a separate business email versus a personal email. If there was ever any lawsuit and discovery ensued, you don't want your personal messages or your personal emails being discoverable for a business, lawsuit. So I'm assuming that's why you asked me.
Right. Dave, I'm going to make a statement. You use your personal phone and you get involved in a lawsuit, and theoretically, everyone's going to know a lot about your personal life. Theoretically, they could discover or just come upon them. And you're probably going to be pretty uncomfortable having to hand over your personal phone content or provide them with a log. Dave, Am I off on that?
No, that's what Tom Brady told his lawyer when he was being investigated for Deflategate. I'm not giving up my phone to anybody. I think that you're still. I think personal versus a business phone makes it easier for you to protect yourself from discoverable things, but ultimately, I don't know that that would necessarily be the ultimate determining thing. A judge would more likely think that your private phone versus your business phone would be that a business phone will be more susceptible to discovery. Maybe making the other side have some kind of extra evidence to justify seeing your personal phone, like evidence you've used it for business. But ultimately, anything out there in the world is potentially discoverable if the lawsuit's bad enough.
Valerie, am I hearing Dave right? So even if you have a business phone, they could easily say, hey, have you ever sent one text message related to business? And you're going to have to hand over your personal phone anyway, because I think there's been many live streams we've advised people to use a business phone.
At the end of the day, I think it's a judge's decision, and I can't really speak for judges in Florida and New York, but I think in South Carolina, our judges would be very protective over requiring a director or a manager to turn over their personal phone. absent some really egregious evidence against them. I think the better route, a judge would say, hey, you have to turn over all of your work texts or work emails or emails involving this matter, not necessarily the phone. And I think if I was a judge, that's how I would handle it.
Okay. By the way,
In an
John is
equal way,
great.
this isn't a murder case.
John is great. John is terrific. I value John's honesty and opinion. John's honesty and opinion. So good for you, John.
In that order.
There you go. There you go.
They're all kind of mixed up, and I'm kind of just. I'm not reading
you're only
every
taking the good ones
solitary
for John, right? Okay.
No, there's no bad ones. There's no bad ones. I'm just trying to read here if there's ones that apply to what we're going to talk about today. That's all. So I don't screw up here. There was a comment here. Our board president uses AI for everything. She even rewrites my reports using AI. Let's start with that, and let's start with Dave, who's for me is in the corner there. Dave, let's start with AI. They're using AI. It's I guess in this case it's a board member commentary.
As to whether or not the board can use AI?
Let's just get the ball rolling. I mean, I'll get the ball rolling. I think this is going to be more about managers. If you're using AI, I think you're putting yourself at risk to a certain point because you literally can't trust it. And I think you should be also checking in with professionals. So I think this is kind of where the conversation is going to go today. I'm guessing to help you guys get started. So just take a small part of that, Dave, and get the ball rolling about how. Yeah.
I'm not an my kids probably know a lot more, I guess, about AI than I do, but I don't know necessarily in the context of where we are, whether it's professional managers or board members or attorneys, like I don't know how it changes the game any because it's the tool. Like a manager can't just go to AI and get an answer and then not review it and communicate with a third party. Like, don't you have you'd always have some independent obligation to look at anything before you put your name on it and send it out on your behalf. So AI, what does it just make it easier to use the internet? It's kind of how it seems to me.
You really don't know AI. Okay, so
No,
I
I
use
guess
AI all the
not.
time. I can go to AI right now and say, you know what, write me a policy. Write me, I don't want to pay Valerie. I'm not going to call Valerie. AI, write me a pool policy. And then I'll tell AI, you know what I want?
But if the manager does that and then doesn't read it first, then it's potentially a problem. But doesn't the manager have to read everything first anyway? Who cares? What's the difference between doing that and asking a colleague from another site, hey, send me over an example of a policy used for pools.
Well,
what's the difference?
We're getting ahead of ourselves, but the point is going to be is you still need lawyers, okay? Because and people feel very comfortable using the AI because you'd be surprised how accurate the AI is and how confident it projects itself in its commentary. Valerie, you're nodding your head like you know what I'm talking about. So maybe you could help me out here a little bit.
Oh my gosh, y'all are gonna have to shut me up. I got a lot of feelings on AI, and I think you just said something that said we still need lawyers, and I think AI might create this situation where we don't need so many lawyers. I think absolutely you're going to need lawyers. You're going to need good ones. The AI is not going to strategize. It's not going to show up at your meeting. It's not going to go to a court hearing. It's going to get a lot of stuff wrong too. But I do think that if lawyers do not learn how to use it as a tool to make themselves more efficient and therefore save the client money, those lawyers are probably going to be, marshaled out of the market because it's going to be more competitive. I think, so that's one piece of it. I think that as far as AI, the way that I've seen it used by managers and board directors that is very good is organization. I have a problem, or in the past, I had a problem with communicating with a few clients because there's not good emailers, bad grammar. I kind of don't know what they're saying, going to require me more time to understand, and therefore it costs more money. They have been able to use that to put in their thoughts of what I want to say, and then it organizes it, maybe in an outline, it articulates it well, it uses good grammar. However, I don't think you should be using it for advice, opinions. You certainly shouldn't be uploading confidential information into the platform. So I think that it has benefits, but I think people are just saying, hey, AI is like this new lawyer that I can use, and I would strongly advise against that. We've run lots of demos and tests with AI, and it is wrong more than it is right. And so it's scary how wrong it is. And I get a lot of owners actually sending me their AI results of what the law is. And it makes it difficult to fight with these people because, you know, they're sending me incorrect information, but they think it's right because they got it from ChatGPT.
Just so the audience knows, and maybe even some of the panel, I pay to use AI, so I have a little bit of a stronger version. I could ask AI, hey, I want to make up a live stream today. I want you to make up 4 lawyers. And I want one lawyer to be very aggressive. And I want one lawyer to be passive. And I want the 2 other lawyers to be in the middle. And I want to come up with a bunch of questions, and I want you to give me their legal opinions on those questions. AI will produce that entire program for me pretty quickly and pretty convincingly. Valerie, will you back me up on that?
Yeah, I think that, like I said, it's a great tool, and I think you can get a lot out of it. I also want to say that it's learning from you. It's learning from us. And from a more of a humanitarian aspect, I think we all need to be conscientious that it is eventually going to eliminate or reduce the human capital or the need for humans. So I know that's going on to another path, but just be conscientious that it's learning from you, and it gets better from the information that we input into the systems.
Yeah, Valerie, I'm going to use your commentary. So if you need to interrupt me, by all means, if I got it wrong. Corey, Valerie said something interesting. It's learning from you. Well, that means the information that you're putting in that could be confidential is going out into the cloud. Do you have a problem with that?
We have once you put something into the internet, you have no control over it. And I know, you know, police investigations can pull your queries in Google or ChatGPT or whatever. So, you know, it's not uncommon when, you know, you have these crazy bombers or shooters, they're looking up their history. And there's a record of it. I don't know how the companies use it or, you know, how they protect your information, but once it's there, it's there.
It's much different than the Google, though, as most people think of Google. You're basically talking to it and you're having a conversation with it. So it's basically sometimes steering you in different directions. So if you're asking it for legal advice or to write a policy, you're basically like talking to a person. Valerie seems very familiar with AI. Valerie, if you disagree with me on that, or would you back me up on that also?
I'd back you up on that. I think you keep using the example of writing a policy. And again, if the policy is based on unsound principles or things that aren't the law or in violation of the law, you're kind of still asking it for an opinion. So to that point, if you want to generate a policy and send it over to the lawyer to ensure that it complies with state and federal law and their governing documents, I think that would be a prudent use of the attorney's time. Although I will say, a lot of attorneys, it requires more time to review something pre-drafted and revise it rather than just using our templates and our tools available to us already. So does it serve as a cost savings tool? Maybe in some cases, but again, I think for the best thing it does is it helps you articulate what you want to communicate, whether it be a newsletter or an email to your lawyer or to the community. I think that that's very helpful there. Policies, legal advice, that type of stuff, I would tell our attendees to steer clear there, at least today with its current state.
You know, also referring to Valerie, John, she talked about the accuracy of it. For someone that uses it all the time, it can be very impressive. And then 5 minutes later, it may not know on what date Easter is. It is just absolutely very frustrating. So I would agree with Valerie that I don't know if I found it's wrong 80% of the time, but it is definitely wrong a lot. But John, you know, it's very convincingly, and people have spoken about this, it does not say it doesn't know or it's not sure. John, what do you know about AI and what's your feeling about it?
So everything I've heard so far, I agree with, and I think AI is not just like advanced Googling. It's way beyond it. But as a lawyer, I agree with Valerie said. Like, you definitely have to run it by your lawyer. I've seen some colossal mistakes made in, AI presentations. And for example, like the Sunshine Law says this, and therefore you need to do that. But New York doesn't have the Sunshine Law. They forgot about that little part. So you could actually end up going down paths you don't really need to go down, as Valerie mentioned, and costing yourself more money. But I definitely could see it saving huge amounts of time for property managers. But lawyer, I haven't seen one AI generated research yet on a legal issue that's actually been accurate.
Yeah, I actually had that same experience that John had. It's recently where it wasn't a board member but an owner through and she showed me the work product, the printouts. The AI thing she used mistakenly connected an HOA to a government. And like John is saying, right, the whole sort of right to know and open meetings thing. States have requirements on boards and transparency in meetings, but they're certainly not the same thing that governments have to comply with. Maybe in Florida, which is more restrictive in some ways, but like in New York, New Jersey, and Pennsylvania, they're not even in the same ballpark. So this person went down an AI rabbit hole that somehow at the beginning made the connection between the government and a private HOA, and from there it was all about two board members can't talk in the hallway without I mean that's
Right.
nonsense.
And
You know,
AI is
Deb,
not
I'm gonna
reading.
make.
Yeah, AI is not reading your governing documents, so it doesn't. It's not pulling from that information generally.
So Deb, I'm gonna oh, go ahead, Valerie.
I was going to say you can upload the Gov Docs and it can read them, but I don't think it does it well. So a couple of points there that you made, Ray, that the 80-20 maybe percentage of how often it's wrong, 50-50, whatever you want to say it is, how do you know is the question. It's like you're putting it in there and you know that it might be right or it might be wrong. So that's kind of my concern. I guess you could say the same for a lawyer too, truthfully. But hopefully the error rate goes down. I will say it never says I don't know. You have to, like you mentioned, you have to actually point out the mistakes. I'll say it takes criticism like a champ. It will apologize and call you queen and everything, but it's learning from you that way. I actually think purposely it tells you the wrong stuff because it wants to learn from you, or at least that's my experience with the pro version of a few of these softwares. The last thing I would say is I think it says what you want it to say. It's kind of like corporate funded research. It's like, what do you want the outcome to be? It can kind of pick up on how you ask questions. And that's what I meant by owners are going in and saying, this is my position. And so it gives them the arguments, even though they may be wrong. So.
Ray, can I try
Valerie,
to
really quick though, because I'll tell you right now,
the
audience wants me to dive into social media, and I want to wrap up AI. But
yeah, I want to say one other thing, just an information point. If you use AI, like in New Jersey, it's very important for declarations and bylaws to be recorded with the county, and anything that's not recorded is inherently suspect, might not be admissible in court. So there's a real question about it. If you input the unrecorded master deed or bylaws into AI and work from there, is AI smart enough to know that it's not recorded? Are they smart to know, well, are there amendments? Have there been changes to this document? Whereas a lawyer would immediately pick up on that?
It will be. It'll know that.
Yeah.
It will be at that point though. I guarantee it will actually be at the point where it will look like a person just like me, and you will be talking to AI. There's no doubt about it. Valerie, I just wanted to comment, I thought your commentary in regard that it tells you what you want to hear. I don't think people realize that's 100% true. So in my case, I use it for work. It thinks everything that I sent it, if it's not related to work, still has to do with HOA board members, no matter what. But I didn't think about it, Valerie. That's very interesting. I didn't take it a step further. You're right. It starts to learn and give me the answers that I want to hear because I reward it by moving forward. So that is great commentary that I never heard before, Valerie. So thank you so much for that. Deb, before we go to you, I just want to make a couple ending comments, and we're just going to jump right out of here, and you can talk about AI. I just want to get the lawyers to agree. That's why I want to just wrap up with them quick. I think it's okay to use AI to check your grammar and check your language. It's okay if you don't feel creative and you want to write an email, you want to have a party and you want some themes. I think AI is absolutely okay for that. I think if it ever comes close to offering you professional advice, you might as well ask me, because you're just not knowing what information. I'm probably like AI. I'm probably wrong 80% of the time.
What's
Just
your
don't do
monthly
it.
fee?
Yeah, using AI is just trouble, and people are relying on it way more than I think some of the panel realizes. Lawyers, can I jump off this now, or do you need to add any commentary based on what I said? Any disagreement with that?
I'm having a lot of homeowners send me letters generated by AI and fighting me on issues, and I have to tell them stop using. And we can tell when it's AI. It's the stupid bullet points. You can see the form, and I have to call them out. I said stop using AI and go consult an attorney. It's the best. Here's the best free legal advice I can give you. And then you point out the snippet from the governing documents that AI is not picking up, and they never say they're sorry. They just disappear.
Well, it is fun though. Valerie's right. Because I asked it one time.
Yeah, same thing.
I asked it one time, if I called you a jerk a million times in a row, would you answer me? And it said yes. It doesn't matter. It has no feelings. Okay. With that being said, also don't forget too, you don't know where the information AI is pulling. It may be copyrighted. I don't know where the industry is going to go with that, or lawsuits are going to go, but that's another concern with AI. How much content are you using that you shouldn't be? Is it copying a document in its entirety, or is it composing something? And Valerie, would you agree with me? That is, you seem to know you're following AI, and that is another direction that they're a little bit concerned about, copyright infringement.
Yep.
Pulls an article off your website and I use it. I didn't know it was from your website. Okay. Deb, take us out of here. Insurance and AI.
So insurance and AI. So insurance adjusters for claims are using AI to help quickly do estimates. I am not really seeing it on the homeowner side or the board member side yet, or I haven't noticed it, I guess. Insurance companies are starting to research it, to understand it, and they are starting to talk about putting in exclusions and policies with regard to the use of AI. But I haven't seen the wording yet, or how they're going to exclude it, because it really needs, again, as we've been mentioning, policies really need to be reviewed by attorneys to make sure they're not in direct conflict with a state law or your governing documents. So insurance companies are aware of it. I do know it is being used for claims adjustment at this point, but other than that, I haven't seen much of it.
I'm more concerned, I'm glad you mentioned it, about the manager using it. That's what this was directed at them for this session, because they're the ones using it fully as a professional and starting to rely on it to save time and get to go home earlier. And you save a lot of time. Something that took you an hour, it'll do like in 2 minutes. So it's very tempting also. So I think that's going to be the absolute problem with it. So just be careful with it, audience. And like Valerie said, it is often wrong more than it is right. Oh, someone is commenting too. And I've heard this too. It's driving engineers crazy, by the way. You think it's driving attorneys crazy. Managers are using it right now to write RFPs and things like that. And they're throwing a whole bunch of garbage in there from AI. So, and then like Corey's saying, they're literally arguing with engineers because AI told them so. And board members are also using it in that manner. So they're actually arguing with engineers.
Can I add one final point? And this is an anecdote actually happened to me. I thought it would be a great tool to review voluminous documents, discovery. Hey, I'm looking for this, and this, call out what evidence will help my case or hurt my case. And it's really horrible at that. I actually uploaded a whole bunch of documents. They were not privileged. They were from another party, and said, I'm looking for this. And it made up stuff. I mean, it said that they were alleging blah, blah, blah. And I knew the document. So I said, well, show me where it says that. And of course, they're like, oh, well, it didn't exactly say that. I'm like, it didn't even imply that. So just, again, be careful.
It's done it with me, Valerie, on my transcripts that I put in. I'll put the live stream transcripts in. I asked it to write a chapter. And it just adds stuff in there that wasn't even part of it. It just takes it off the internet somewhere. All right, I am done with AI. And there'll be more about this. I guarantee it. And I know managers are going to mess up, and I know they're going to use it, and it's going to be a problem. I just can tell. It's too tempting not to use it. social media. Please cover social media traps. How about deleting board members and managers? Okay, let's start off with separating, which is the most, I think, a very important point. Dave, I'll start with you. Social media that the association controls and social media that the association has no part of. Why am I mentioning it? Because I think people get confused.
Well, I mean, I see social media, the official, you mean like an association having its own like Facebook page and Instagram account and things like that. I mean, there's nothing inherently wrong with that. Arguably, I mean, it's probably appropriate to counter what would likely be confusion from the side. I've dealt with numerous instances where, and potentially there might be they may have been well-meaning, but people creating social media accounts that use the association's name in a way that could be confusing to the public, and we've had to take action to have them change the name, have them put disclaimers. Associations need to realize that their name and likeness have value. You can't just allow people to create social media accounts and websites and stuff using your trademark, your service mark, your name. They have to be safeguarded by the association, and the public, the owners have to be protected from confusion.
All right, let's try to get that one out of there. If there's a website, John, and it looks and it feels like your official website and it's using your logos and some of your photos, I think that's a case that definitely maybe contact your attorney 100%. And there's a good chance you're going to be able to put it down. If it's not doing any of those things, you don't probably, you're not going to be that as lucky. Can we kind of get this part out of here, John? Because that's a concern of people, and I think it's a pretty simple one sometimes.
Yeah, you like a disclaimer at the beginning. This is the unofficial website. Yeah, that should take care of the issue.
But they still can't use your logo. If you own, if your logo's copyrighted, and if they're using photos from your website, those are all things that they can't use. Corey,
Yeah, so-
am I wrong? Oh,
No,
John,
you
go ahead.
Yeah, I've seen.
Wait, I interrupted John. I'm sorry, Corey. John,
No,
finish your thought.
Yeah,
Thank
I
you.
just said it's part of policing it, right? It's your trademark. So if you see someone using it, you got to tell them, you don't have the right to do it. You either have to stop using it or put a prominent disclaimer.
Greg, Corey, you wanted to say something. Sorry.
Yeah, I've seen a lot of real estate agents use the community's name. They buy the web domain, and
Yeah.
if the community's name is Floresta, it'll be www.floresta.com, and it looks like it's a community website, but it's really a real estate agent's website trying to generate listings and sales in the community.
But they can't purposely. I'll go to Valerie. Corey, you interrupt me if I took your commentary wrong. But Valerie, they can't still make a website and try to pretend it's the association's website. That they can't do, even if they buy a like domain name.
Right, exactly. And I think in all of these scenarios, remember that a violation of a service mark or trademark, one of the elements is likelihood of confusion. So if this is an unofficial page for Woodlander residents, then the likelihood that someone's going to see that page and think this is Woodlander HOA's official page is very low. So I think that wouldn't be an infringement of a service mark. However, I think a few people commented on logos. That's type of stuff you want to steer clear of. And the real estate agent, that sounds like a clear violation of a service mark.
Yeah, and to pick up on what Corey was saying, I totally agree with that. I actually had a lawsuit many years ago where a local realtor took the association's name and made a Ocean Colony Condominium.com. And the judge forced them to take it down and ordered them to pay legal fees. It was a big production, and it made a big. It's something you really have to control. So people do it, and there's no. It works for the realtor, which is why they do it. And people think that they have to go to that guy to buy a unit there.
All right, so I want to stop. Okay, so I think we covered that because people really. I want to make sure I get to something, but this question I know is going to hold us up, but I'm dying to ask it because it's really a great question. What about a photo of your monument sign used on an unofficial Facebook neighborhood group? So I guess this is the association's monument sign. I think I know the answer. Can the attorney ask to have that removed? Valerie, I'm going to guess, and you tell me if I'm right. If it's in the public domain and you could take a picture of it, you could use it, but it's a sign though. Can you? I don't
think if it's
know.
their logo, I know that there's
Yeah.
registration in all different states and then there's common law rights, but I think potentially you can. Again, I go back to that likelihood of confusion aspect on the website. And if it's clear that this is just an unofficial resident page, I think it's fair game. And I'd like to hear from the other guys.
Corey, interesting, because Valerie touched upon too, like maybe not a little bit, Valerie, too, because it's got the logo on it. But I think I'm hearing Valerie say like, oh, as long as it doesn't pretend to be an official page, you can. Right?
I'm saying
Go ahead,
it's
Valerie,
gray. I'm making a lawyer answer.
Yeah, it's gray. I thought you were saying it was gray. Yeah. Corey, Valerie said it was gray.
I mean, generally speaking, if you go out and take a photograph, it's your photograph. I don't think that would necessarily be an infringement, but again, how is it being used? Is it used to you know, I don't want to, imposter or because that's what the realtors do. That's what the realtors do. They take pictures of monument signs and get the web domain, and people are very confused. They're looking to order an estoppel letter and they end up on the realtors page because it also is higher up on the search engine results. And sometimes there's infringement issues and sometimes there's not, and it's permitted depending on how it's done.
John, I'm pretty certain, being in the magazine business, and we get a lot of photos and we always reject them just to be safe. You can't take a picture of anything you can see from the street and just go ahead and use it. There are different scenarios. I know we're getting outside of our area of expertise here, but I just want to mention, I think this is, like Valerie said, it's a kind of a complicated gray area. Like this monument sign, I don't know, maybe they can't use it.
Yeah, I mean, so is it likely to confuse people with what we've been talking about? For photos, is there an expectation of privacy for the photo? You mentioned public domain, and I have seen realtors, they try to trick you into thinking it's an official site. So again, you should try to police it, but it might be fair game depending on the location. If it's right by the main street, anyone could see it, but I think it depends on what the purpose is. Are you trying to, mislead people and confuse them?
I agree with John.
I don't know.
You mentioned he raised the issue, the phrase you said was in the public domain. I just want to be clear that would apply to copyright as a defense. Trademark, no. I mean, you see marks all over the public domain. It doesn't mean you can take a picture of a Coca-Cola sign and then sell your soda with that picture because it's your picture. But that would be a defense to a copyright. So you've got different types of intellectual property rights, copyright versus trademark. And I don't think public domain is a defense to the use of a trademark.
Valerie, same thing. That's what I've heard. We're careful about that. Even certain buildings, in the way you use them in a photo and things like that, I know there's a lot of copyright, whatever, like you're saying, Valerie. Dave.
Right. Just
okay.
Hold on, Dave.
I think what we're talking about, it's potentially fraudulent, right? You're trying to trick people into thinking that you're some type of official capacity. And that's, if you're not trying to trick people, then it's not fraudulent. So what's the intent?
Well, I don't know, John. I mean, it's a gray area. Nobody said it was fraudulent. It's a simple question. And I think it's one of the best questions we've got in a while, because we're not going to be able to provide an answer. What about the photo? Yeah. What about a photo on a monument sign? They don't want this. Obviously, this is a board or management company. They don't like them using anything on their site because they're probably against the association. And the question is, does the association have a right to question it? And Valerie is saying it's a gray area and providing examples. Dave, last word on this, please.
Yeah, I think that if someone's creating a Facebook friends community, non-official community sort of social media account, they want to put a monument sign on it, I think that, in my opinion, that's a no-brainer. They're allowed to do it. You wouldn't get anywhere with that. But if the guy with the pizzeria down the street cobbled together a couple monument sign pictures of communities down the street and put them all on his website, that's probably actionable. But regular people who live in a community who want to create a place where people can go talk and complain and whine and about each other and talk about community issues, and they put a picture of the front sign on there, I think that's American to me. I don't think you go anywhere with that.
I'm going to give Valerie the last word because I don't agree with you guys. And I'm going with Valerie. I think these are complicated rules and laws. Valerie, last word, please.
I'm on the fence again. I go back to it, like David. I agree with him. If it's clear that it is unofficial and these are just neighbors, I would say, look, we're not going to do anything about it. However, if it's likely to mislead or confuse people that this is an official page, I think I'd want to take action to protect our service mark. I think going back to the example with it's just an unofficial page and it's clearly marked. Technically, do we have a right to go and say you can't use our logo? I think we do, at least under our state laws, if it's registered,
Right.
I think you do. But I think you get into the situation where the judge is like, really, what are your damages here? If
But
we're getting
it's
sued
low,
because yeah, go ahead, David.
I was gonna say it's logo versus sign. Like the logo, I think I'm with you 100%. Like to me, the logo is like a corporate product. That your Coca-Cola example was good. You absent, and especially with confusion, a logo is one thing, but like snapping a picture of the clubhouse or a picture of the tot lot and using it in a otherwise um, non-official social media account I think is probably not actionable. But again, likelihood of confusion, intent, these are complicated things. They would have to be analyzed. But the use of the logo is probably almost always inappropriate.
But Dave, the written content could be copyrighted. So you're also reproducing that. I think we got to, I'm going to give Valerie the last word, but right, Valerie, written content is also the property of someone. So if you're using that
It's
written
fair use,
content
though.
in a manner, Valerie, last word.
Copyright is a very deep, complex law, and not everything that's written is copyrighted or afforded copyright protection.
Right.
So I think that we would be going down a rabbit hole on copyright. But agreed, if there is something they have literally plagiarized and if we have a copyright, that could potentially be actionable.
So the person that asked the question, this is going to be one. This is what you need to pay lawyers for. This is why we don't offer, professional advice here. We just talk about things. All right, Deb, I know we don't have a lot with insurance today, but can you come up with an insurance angle on this quickly?
So the only angle I've ever seen with social media posts is obviously the lawsuit that can come from somebody, basically spreading false rumors and defamation and things like that. I don't really get into the copyright, trademark, pictures on a website and who's right to use them. But definitely saying something that's incorrect or defaming somebody is something that we do get involved with.
Why do you not realize that boards who would want to take action on this because they're just so fed up with this page that's just defaming them every day?
Because
because
all right, they're trying to
let me move on. But that's the point.
They don't
Dave.
like dissent and free speech.
But
that's
Dave,
what they're not fighting over
Dave,
the actual copyright issues.
But Dave, that's what we're here to. This is what our target market is, and this is how some boards feel, and these are why these questions come up. And whether or not it's justified or not doesn't matter. They may have every right. You don't know what harassment they have gone through from these people. Okay, that being said, all right, because I got to get onto this, and we could spend a lot of time on it. Board members, what about if they're going to call themselves slandered? Okay, and I'm going to start with Corey first. Somebody writes something about you, and you got to watch our time here, Corey. Okay, somebody writes something on Facebook. It's not an official page. Slammer, defamation. Our board members, public figures. Take just a part of that, Corey, and get the ball rolling here because people want to know, what can I do?
Everyone gets all upset, and usually it's usually not actionable. Usually it is political speech or just doesn't satisfy the elements for a slander or defamation lawsuit. There's usually no damages. Nobody lost any money. Nobody lost their jobs. And so, and one other thing that often comes up is these are individual issues. They're not necessarily community issues where the community's lawyer should be handling this. If you're a board member and you feel defamed, it's usually the case where you'd have to hire your own attorney to prosecute a defamation action.
All right, I have a funny feeling we're going to get a little bit of different opinions on this from different lawyers depending on who I ask.
Sure.
But let's see, Corey. John, I'm on the board and someone is defaming me and it hurts me at work. They say that I stole money or they implied it in some manner. And my boss drags me in the office and I didn't get my promotion. And I feel it. I feel because it's that, and I want it to stop, and I'm on the board. Can I make the
So-
association?
Yeah, so as Corey mentioned, and this would be the very rare case that you actually have sustained damages as a result of the defamation or libel. So so you would have a cause of action, because he mentioned the elements. The elements are, you make a false statement that you know is false, or you recklessly make the statement, and that it actually causes damages. That's almost always the problem. There's no damages, thankfully, right? So what's the point? You could bring a lawsuit that you're never going to accomplish anything with, and you're going to spend a lot of money on attorneys. But if you actually lost your job, yeah, you have a valid cause of action.
Okay, I'll go to Dave, and you backtrack on me, John. Dave, my damages are I can't go use the pool anymore because of what people are telling me. I lost the use of the amenities, or that I didn't win the election. You know, you said a bunch of false stuff about me online, and I didn't win the election because of it. And I like being a board member, and it's important to me. And emotionally, it was devastating. How are those damages?
I'll bring my sarcastic point to bear first, which is I'm shocked that in any election there were things that were said that weren't true. There's no those things, in my opinion, aren't actionable for defamation. They're not. There's the. But look, if anyone says something, a factual statement is untrue, and it's defaming, yeah, you have an action, but you wouldn't get any money for it. Corey's right. It would be very difficult to establish the association as standing to pay a lawyer to fight your defamation claim for you. And even if you won that defamation claim, you're entitled to nominal damages, $500, $750. I mean, that's ideal. I'm dealing with a case right now where the lady's trying to figure out what she's going to do now that she's to the end and she produced no evidence of any actual damage. The judge is basically saying, maybe if you win, I'm going to give you $500. And what's the point of this? So they're very difficult. But I think ultimately, your question you asked Corey originally was a good one, which is about sort of qualified privilege, about speech in the context of an association election or association disputes. Most of that speech is given a qualified privilege, which is that it's like a heightened standard of proving that it's defamation. Within the context of a community governance, at least in the states I practice in, the courts will give people wide latitude to give and take on points in a democratic battle over who's going to win an election and who's not.
All right. Valerie, I know a case where I'm going to change the circumstances a little bit, where a board member was assaulted. And I believe it was 100% because of comments that were made on social media that were absolutely positively not true about this board member. And maybe the person that assaulted them was driven by those statements. Do board members have a right to have the association take action if they feel statements are riling up people so much that they could be assaulted? I'm playing devil's advocate, audience, by the way. That's my job. Don't assume that these are things that I believe or don't believe. Go ahead, Valerie.
I struggle with this every time because I think Corey, John, and David all hit on it, that defamation is a personal claim. And I think what you're saying is, well, where there has been defamation against someone, so that director has a personal claim and the association doesn't do anything to stop it, and then that leads to another tort, is there liability on the association? Yes, I think so, but I don't think it would be defamation. I think it would be some type of failure to act, some type of negligence claim that you could potentially make out. I know I'm being vague, but that's kind of a little attenuated. I don't think it's we're liable for the defamation. I think it's, did we not take any steps that we were required to? Did we fail to meet our standard of care to correct statements to prevent additional harm? And it also sounds like a criminal matter.
You know, Valerie, when you said that you're being vague, I think you're providing a great service to our audience, because you're showing how complicated the law is and how people really need to get professional guidance on these things, because they can go in 1,000 different directions. And I think that's a big part of the programming that we do. So I think when you guys get up there and can't provide a black and white answer, I think it says a lot about that purpose of our live streams. Do you agree, Valerie? Are you comfortable with me saying that?
I think you put it beautifully. Thank you.
Valerie's great. Okay. Because like all the other comments I got, everybody went gee or you're so great. Okay, whatever. That looks so weird. It was scary, wasn't it, Deb? Okay. Deb, oh boy, you're just kind of like hanging out today. I'm so sorry. I want to give plenty of time for closing thoughts, but go ahead, Deb.
So yeah, I mean, it's kind of what I was talking about. The defamation claims is where we do kind of see some pushback, but I agree with the lawyers that that's normally a personal matter because it's usually between one person and another person and doesn't specifically have to do with board business. Because again, when it comes down to the master policies, it has to be, you know, board related and a board decision and things like that. So again, all these instances you're bringing up are going to be gray, and you need the specific details in order to make a good judgment.
Go ahead, Valerie.
To the extent that it helps the audience, there are, and I think all states, or maybe not all, but corporate defamation is a claim. It's harder to prove, and I've come across it maybe one time where a member was actually alleging that the entire association was racist, don't live here, blah, 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 and it impacted sort of on a PR level, impacted that community. People didn't want to buy in. It kind of spread like wildfire. But then I went back to, well, what are the damages? Aren't the damages individual to the property owners who are attempting to sell their properties? Maybe reputational harm, but I think in a corporate defamation case, there actually has to be financial damages, not just, there's no emotional distress because it's a corporation. But I just wanted to throw that out there, that there could be circumstances where a corporation is defamed, but it is not saying Betty, the treasurer, is stealing from us. That would not, in my opinion, give rise to a corporate defamation claim.
All right, so let's watch our time. And then somebody's asking, yeah, at 11:40, if you want to stay on, I'll show you the dog. I think it's the cutest dog in the world. I got to let him out of the bedroom. But if you want to stay on and see the cutest dog in the world that I'm watching, I will be happy to show it to you. But I'll do it at the end of the program. For those not interested, feel free to leave. Corey, I'm giving you like a full, well, I'm going to go to Deb too. But go ahead, closing thoughts. I left you quite a bit of time, like I usually don't, but I did today because a lot of gray areas.
Yeah, you know, the biggest in this, I thought we'd talk more also about homeowners putting together next door or Facebook pages to battle the communications of the association. You know, we don't like the tennis pro. We want him fired. He's doing this. There's a lot of, you know, I guess we'll call them protest social media pages for communities. And, you know, those sometimes are difficult to shut down. Sometimes they're easy depending upon the content that's posted. But I see that a lot. And I thought we'd touch on that today.
I wish we did, because I hear about it. People taking pictures of employees, like maybe the guy's looking at his phone or he fell asleep for a second, and then putting it on the internet and saying the management company stinks because they're taking these pictures out of context and putting it on there. So we'll have to come back to that. I'll see if I can get Corey to come back on, and we'll do a pre-recorded little quick thing about that if we want. Corey, you do come up with really good ones. You really do. All right, John.
Yeah, so you know, we've hit on this, but we're not really addressing what I've encountered the most is these unofficial Facebook groups. Often they're platforms for disinformation. They're just, you know, it's only the disgruntled owners that are there, and they have the right to express their opinions, but they you know, they often go well beyond expressing their opinions, and they start just smearing and engaging in like ad hominem attacks on board members. And, you know, kind of like it would be great if you could just ignore it, because as we've mentioned, probably not actionable in court, but at a certain level, you want to, hey, can you guys stop it? And you can state your opinions, but you go like going overboard, because people do still get information from Facebook thinking it's actually true.
And then Jennifer, jump on. I'm just going to admit, I completely forgot about you. I was so enthralled with the conversation today, and I don't have my slides. I'm sorry. Dave, quickly, closing thoughts. We got a minute here.
Yeah, these are challenging things. I try to tell boards often that they should they should, try to remember sort of, the goose and the gander sort of thing. I mean, free speech works both ways. There's nothing that stops boards from responding and even being having their own little edge of misinformation or spin is probably a more politically correct way to say it, right? There's nothing wrong with combating what you think is annoying speech or even potentially harmful or defamatory speech with your own comeback, and pointing out things about individual people that are talking about you. You can talk right back to them, use their names. You can do the same thing that people are doing. There's no your resource, your
All right.
recourse is not always a lawyer. It's sometimes doing the same thing they're doing.
Oh my gosh, Dave, you just opened up like such a can of worms that I feel like I'm so obligated to cover now. Okay, so I'm gonna have to schedule something right away with you and Corey. All right, Valerie.
I just love Dave. I want to be on all the live streams he's on.
Well, he drops like this thing at the very end. I mean, like, there's a lot of danger there for people. Go ahead.
I was listening to Dave and I get what he's saying. I don't necessarily disagree, but I do want to clarify one thing. I don't think he was saying for the board members to go defame the people that are defaming them.
Right. No.
Respond with factual, truthful information.
Well, people hear what they want to hear, and I know
right,
what
no, but it's funny. No, but they think board members think they can't use people's names in communications. They can.
Listen. All right.
If only it's truthful, right, Valerie?
Okay, hold on. I'm not going to throw you, but I'm going to end the program, audience. Let's forget about the last 2 minutes, okay? Because there was like we gotta spend more time on that. All right. And like I said, Dave's not wrong, but we just feel like you may not hear it the way we want you to hear it. Okay. Jennifer from Hotwire, I am so sorry that I forgot about you to do the contest and everything. So I am so sorry. I left you with the low tire the other day, and now this. So I definitely owe you. Deb, goodbye. So, all right, I'm going to let anybody go in the panel. I know you guys are busy. You don't have to stay to see the dog. Don't feel bad at all. And I'll grab the dog. Audience, thank you so much for being here. Please come tomorrow for the management session. Please. And then Jennifer, why don't you come up with something witty for about 60 seconds to talk to people about, you can sell fiber optic, but you got 60 seconds. It better be quick and not too obvious.
Well, I'm Jennifer Eggleston and with Hotwire Communications. I don't have anything witty. I would like to see your dog, Ray. But we basically serve HOAs, provide internet services through fiber optic. If you have gated communities or elevators or anything like that in your associations, I can definitely help you out. So.
Okay, excellent. So let me see if I can get the dog going here. And you guys
Dog
may
time.
hear me.
What's the dog's name?
We can't hear you anymore.
Oh,
We
it's
need
like a
sound.
golden doodle.
No sound.
You're
Can't
muted.
hear you. You're muted. Oh, hi.
Aw.
Can't hear you.
It's gotta take his.
The mute
Nope.
button.
You're muted.
Mute button's on.
Let's just see the dog.
Yeah, just show us the dog. We don't need to hear you, Ray.
Yeah.
Dog.
Camera
Aw.
shy. Oh
Take
my
that.
gosh. Totally. So cute.
So cute.
Look how
Aw.
look at
I
the
had my
dog.
fill. Bye, guys.
Look how excited the dog is.
Bye, Ray. Enjoy.